All right.
All right. Good morning and welcome to an oral argument session of the Fifth District Court of Appeal on Zoom or YouTube. We have one case on the docket this morning at 9:15. We appreciate counsel being patient with us as we ironed out our technical difficulties. The case is Weaver versus Volusia County. My name is Rand Wallace. I'll be presiding over the oral argument this morning. I have joining me on this panel from Orange County, Judge Jay Cohen,
Morning.
and also from Orange County, Judge Molly Nardella. I would just ask that counsel have your microphones on mute and mute any noise-making devices you may have in the background so that they don't interrupt the presentation. I will assume, Mr. Barr, that you want 5 minutes of rebuttal unless you tell me otherwise.
Yes, please.
And yes, then Mr. Barr, you may proceed when you're ready.
Good morning, and may it please the court. My name is Chad Barr, and I have the pleasure of representing Ms. Kathleen Weaver this morning. Ms. Weaver proudly and fearlessly served the residents of Volusia County as a firefighter from 1999 to 2012. Every day she went to work, she put her life.
Mr. Barr, listen, we're not here to rehash the facts. We know what the facts of the case. The legal issues are what we're here to address, and that is whether this was a substantive or procedural change in the law. So why don't we get to that?
Thank you. I just want to just briefly discuss the circumstances surrounding the Florida legislature's enactment and Governor DeSantis's passing of I'm going to refer to it as the Firefighter Cancer Bill, if that's okay with the court, just to be consistent. That law was passed in 2019, and that law was introduced because of some alarming stats regarding the connection between firefighters and cancer. According to the International Association,
is any of this going to help us decide the issue of whether this was substantive or procedural?
I think it helps to understand the issue of the fact that the statute is remedial as it relates to the rights that were already existing for firefighters and former firefighters to seek damages for being diagnosed with cancer after their time serving as a firefighter.
Can we begin with that? Can we start talking about what rights existed, what a firefighter was entitled to pre the passage of the statute? Because in your initial brief, you say very broadly that these remedies were already available to firefighters through the workers' compensation statute, but I don't know where, and I'm hoping that you can help me with that. So with this new statute, we have a one-time payment of $25,000. We have full coverage for treatment. Where can I find both of those in the workers' compensation statute?
Well, Judge, those specific remedies are not in the workers' compensation statute. But I think the focus of your question really should be on the legal rights, not the remedies. If we're talking about a statute that affects the remedies, then we're not talking about new rights. So the right here is the right to pursue compensation for an injury that occurred during the time that Ms. Weaver was a firefighter for Volusia County. So,
counsel, don't I look at both lenses? I look at not only who may be receiving the benefit, but who may be bearing the cost.
I don't agree with that when we're talking about whether, we do look at that if we're talking about whether this was a remedial or substantive, but what remedies are available?
If I have a new burden put on the county, a new obligation put on the county.
That's not a new obligation. That the obligation is to pay benefits if there's a diagnosis of cancer. A former firefighter or a current firefighter who is diagnosed with cancer can pursue benefits under the workers' compensation statute broadly. There's so long as it's within the confines of the statute. This is simply providing an alternative.
Does workers' compensation provide health insurance?
Does workers' compensation, it is a form of health insurance, I would argue. It provides a definite benefit.
It's a monetary benefit, not a health care benefit, isn't it?
Correct. And as with this is a monetary benefit.
Well, it's a healthcare benefit, isn't it?
No, I would argue that it's a monetary benefit, but I think that just kind of proves the point that it's remedial. The right is not being expanded. The right is still the right to pursue benefits for the diagnosis of cancer. We're not asking that she be entitled to receive benefits for something other than what she always was able to obtain benefits for.
Could she go to a doctor and say to the doctor, here, I've got workers' compensation and treat me?
I don't think I understood or completely heard the question. I apologize.
Sure. Could she go to a doctor and say, I've got workers' compensation coverage for my cancer diagnosis, treat me?
If she was covered under workers' compensation, yes.
Really?
There
Under
are rules regarding
what aspect of workers' compensation will the doctor be able to obtain payment?
If the doctor is operating within the workers' compensation scheme, then yes, the doctor can receive reimbursement for that. But what we're talking about here, and when we're talking about the difference between substantive and remedial right or changes, when we're talking about spending all this time talking about the remedies, it's proving the point that this is a remedial change and not a substantive change, because we're not saying that Ms. Weaver now has the right to seek injury or seek damages for some injury that she was not able to seek damages for in the past. She's able to seek damages for something that she was always able to seek damages for. And so when we talk about the difference between substantive laws are those that create new rights or take away existing rights. The right is the injury. The right is not the remedy. Procedural laws are laws that address the means and methods under which the duties and rights are enforced. And remedial laws operate in furtherance of existing remedies, but do not create new rights or take away vested rights. As this court held in Campus Communications versus Earnhardt, one of the primary purposes of a remedial statute is to correct or remedy a problem or redress an injury, which is what we're talking about in this case. In St. John's Village versus Department of State Division of Corporations, this court stated that by definition, a remedial statute is one which confers or changes a remedy. A remedy is the means employed in enforcing a right or in redressing an injury. When a statute is procedural or remedial, it must be broadly construed. Cases addressing whether statutes are substantive or procedural sometimes discuss how difficult it is to draw the line. And that's because many times newly enacted statutes accomplish both goals, they're both substantive and procedural. While that distinction is not always clear, and quite frankly, I've handled a couple of cases before this court where they're not clear. In this case, the firefighter cancer bill quite clearly tells us that it is not creating a new right, but is addressing an existing right and merely giving the firefighter an alternative to the workers' compensation process. So what we see here is that there are no new legal rights created and there are no rights being taken away. In Florida, a firefighter or a former firefighter could always pursue a workers' compensation claim if they were diagnosed with cancer. Under our workers' compensation laws, substantive rights are established by the date of the injury, not the diagnosis. The firefighter cancer bill does not add or limit to these rights. The only thing the firefighter, go ahead.
Can we go back and talk about the burdens and obligations on the county and whether that's the same or different vis-a-vis workers' compensation? When you have workers' compensation, you have a pooled risk, right? You have a workers' compensation insurance that's going to be bearing the cost. Now you want to take it directly out of the county. Does that affect the analysis? And if so, why not?
I absolutely do not think it affects analysis at all, because what we're still talking about is the remedy. So we've not once talked about the legal rights. We've only been talking about the remedies. And if we go back to this court's own holdings, that's remedial. Regardless of how the money is being paid, it's the same payor. And so we're talking about a remedy. We're talking about redress of an injury. That is remedial. It's not substantive. I want to touch. Go ahead.
No, go ahead, counsel.
I just wanted to say I wanted to touch on a case that that Volusia County cited in their answer brief. And I actually think it helps us quite clearly. And that case was the Walker and the Laberge case. That's a 1977 case from the Florida Supreme Court. In that case, the Supreme Court was confronted with the question of whether an amended statute withdrawing immunity from suit in workers' compensation cases applied to permit an action for damages in negligence brought on behalf of a worker who was injured before that statute's effective date. So it affected the rights of the parties. the Volusia County is citing that case to say that that this is a substantive change in the law, when that case is completely different. But what's important is that case cited to two cases which I believe squarely address our issue, and this court needs to consider them. The first case that the Supreme Court addressed was the Teleservice case versus General Capital Corporation, which concerned a retroactive application of an amended statute permitting a corporate borrower to recover only interest and not principal on usurious transactions. So it dealt with what amount of remedy are you able to obtain when it comes to a right that you have. And in that case, the court held that an action predicated on remedies provided by the usury statutes created no vested substantive right, but only an enforceable penalty, which had a retroactive application. So the penalty, the retroactive application of the penalty, was not unconstitutional. And the other case was that the Walker and Laberge case cited was Summerlin versus Trammell. And that case concerned the burden that applies in a guest statute when it comes to riding in someone else's car. Volusia County's argument that a subsequent statute that provides an alternative remedy in the context of a workers' compensation claim is substantive is simply unsupported. While the general rule followed in Florida is that the law in force at the time of an injury or accident governs one's rights to workers' compensation, and later amendments are not applicable if the effect of the amendment is remedial. The retroactive application of the statute is permitted. And we see cases in our case law, for instance, Myers versus Carr Construction. In that case, the first district held that a statute that increased the interest rate for a workers' compensation claim from 6% to 12% was remedial and could be applied retroactively.
Well, if we get to the retroactivity of the application, doesn't there have to be a clear intent stated to apply a statute such as this retroactively?
If this is a substantive statute, then yes, there has to be clear intent in the statute, expressed in the statute, that the statute be applied retroactively, and then it has to pass the constitutional test. That standard doesn't apply when it's a remedial or procedural statute. There's no bar to the statute being applied retroactively. And I believe that's well established in this court's.
No, I'm not debating that concept with you. I agree.
And so I just, unless the court has any other questions, I think I will just reserve the remainder of my time for rebuttal.
Okay, Assad. And you're on mute.
See, it wasn't just me.
At least Judge Cohen did it first.
Right.
Good morning, everyone. May it please the court, London Ott, Assistant County Attorney on behalf of Appellee Volusia County. And I quickly want to raise, Judge Cohen, your question that you posed straight out the gate as to whether the statute, section 112.18.16, which I will just call the statute for ease of reference, whether that's substantive or not, and it absolutely is. And that's to your point, Judge Nardella, it creates not only new rights, it confers new rights for firefighters, a new right of entitlement to new things that were not available under the workers' comp scheme, but also new obligations for public employers. And also, Judge Nardella, to your point, you had brought up the fact that workers' compensation benefits are paid out of a pooled risk, and that's exactly right. And the benefits that a public employer would pay pursuant to this statute don't come from pooled risk. They don't come from group health. They actually come from a specially created third-party insurer, Chubb, that is a special purpose entity, essentially, that is used to dole out claims made under the statute that Chubb deems appropriate. So for all those reasons, and obviously the ones laid out thoroughly in our answer brief, the statute is absolutely substantive. It confers new benefits that did not exist before, and as I just said, requires public employers like Volusia County to do new things that they didn't have to do before for qualifying claims. It requires the county to pay for covered cancer treatment and also a $25,000 payout upon initial diagnosis. In addition to that, it also requires public employers to provide disability benefits, disability retirement benefits under subsection 3 of the statute, as well as line of duty death benefits under subsection 4. So there's a whole litany of things that are new, that are provided for by the statute that are completely separate and apart from what's currently offered through workers' compensation.
Now, Mr. Barr is making a distinction between a right and a benefit. What's your response to that argument?
Judge Cohen, it's the county's position that the new right that is created by the statute is the entitlement to benefits. It's not.
Sounds kind of circular in reasoning, doesn't it?
No, the new right that is conferred. Substantive statutes create new rights and create new rights. And the new rights that are provided by the statute is the right to receive a $25,000 cancer payment upon diagnosis of cancer, as well as certain disability benefits, as well as certain death benefits, as well as covered cancer treatment. So those are the rights that the statute creates for qualifying individuals. And again, there's no, as the panel pointed out during Mr. Barr's argument, there's no intent by the legislature to apply this statute retroactively. The legislative intent has to be clear and unequivocal. It cannot be left to implication, and that's principle's been well established by the Florida Supreme Court in the Larson case from 1947, as well as Rosenwald versus State, Florida 4th DCA 2019.
If that assumes that it's a substantive.
Correct.
Right.
Correct. And, as I was preparing this issue and litigating in the trial court and also preparing it for appeal, a lot of the cases use very boilerplate language, right? When they're defining, well, what's remedial, what's procedural, what's substantive. The cases typically say, well, remedial statute furthers existing rights and remedies. Well, what does that mean? And an example of that is found in City of Lakeland versus Cantonella, Florida Supreme Court, 1961. In that case, the statute at issue was considered remedial or procedural because it empowered the Industrial Commission, I'm not sure what that is, some sort of adjudicating body, to assume jurisdiction over certain controversies. In that case, the statute didn't create anything new. It just tweaked something that was there before. And Ms. Weaver puts a lot of stock behind the argument that the statute is remedial because it creates an alternative remedy. And the statute does create an alternative remedy. The statute clearly says that in its text. However, there's no authority cited in the initial brief for the proposition that a statute that creates an alternative remedy renders it remedial. Neither the initial brief nor the reply brief cites any case to support that proposition. And also, for what it's worth, and it's the county's position that the statutory language is clear and there's no need to go outside of the statutory text itself to determine legislative intent, but the enacting legislation itself found at Chapter 2019-21, Section 5, Laws of Florida, which is cited in our brief, clearly states, quote, "This act shall take effect July 1, 2019. The inclusion of this language actually rebuts the argument that this statute was intended to apply retroactively. And that
was intended to apply retroactively?
Well, it rebuts Ms. Weaver's argument that the statute is intended to apply retroactively.
Counsel, if we find that the statute is not substantive, then what do we do with the enacting language? How does that impact our analysis?
Oh, well, I had simply said that I stated a little awkwardly, but what I was trying to say, and maybe I wasn't clear, was that the fact that there is an effective date of July 1, 2019 means that the statute applies prospectively only.
That means every time you have the enacting date, you're saying that always means that statute, it's purely on that language, is never meant to apply retroactively. Is that correct? I would think every statute has an enacting date. This statute is effective as of this date. Now, whether it has retroactive language within the body of the statute is another question.
Correct. I think that the effective date in the enacting legislation is persuasive for this statute's purposes, where it's already substantive in its content. It confers new rights and remedies, and the fact that the enacting legislation says it takes effect July 1, 2019 going forward makes the county's case that much stronger.
I'm with Judge Wallace on this. Every statute has an effective date. I don't know that we gather anything from that.
Okay, well, even if this panel's unpersuaded by that argument, which it seems like you are, we still have the text of the statute, which is all this court needs to reach the right result and to affirm Judge Weston's order awarding us final summary judgment in the trial court.
All right. So if you're diagnosed with cancer, you're a firefighter, and you're diagnosed with one of these cancers, you could seek workers' compensation even after you've retired, correct?
No. So it's a little, workers' compensation is a little, it's its own niche. So it's Chapter 440. In order to have a covered claim under workers' compensation, the employee has to be employed on the date of injury. And so assuming that the date of diagnosis is the date of injury, if the firefighter is retired on the date of diagnosis and no longer employed with that employer, they are not eligible to file a workers' compensation claim.
So this would, go ahead, Judge Cohen.
Oh, go ahead.
So this would create a new right. If
Absolutely.
workers' compensation, if you're saying to us, and we're going to ask Attorney Barr this, but if you're saying to us that under workers' compensation, there would be no right for the former firefighter who is now retired to pursue benefits under a workers' compensation a statute, even if, let's say, their cancer was related, possibly they could even prove it was caused by their employment as a firefighter. This statute would have then given them a right which they didn't have previously. Is that your argument?
Yes, that is our argument. And
If the diagnosis, though, if you have an expert that comes in and says, well, this cancer was caused by exposure to hazardous chemicals or materials during the course of employment, but the person has retired in that interim, are you suggesting there's no coverage?
It would come down to the legal question of when the date of injury is.
So they could prove cause. Sorry, go ahead.
If the judge of compensation claims would find that the date of injury is the date of diagnosis, and that's their date of accident for state reporting.
Well, what if you had an expert that comes in and says, no, this was the injury occurred during the course of employment, not as of the it didn't, the date of the diagnosis is the diagnosis, but an expert comes in and says, no, but this occurred not on the day of diagnosis. It occurred back when she was employed.
Well, assuming we're still talking about the Chapter 440 scheme under workers' compensation, if that's the legal finding by a judge, or if the parties agree to the date of injury being the date of exposure, perhaps, then yes, then if they were employed on that date of accident, if that's considered the date of accident, then yes, they would be covered. They could file a claim, assuming it's deemed compensable, whatnot. they're still subject to a 2-year statute of limitations to file that claim. However, I want to jump back and talk about this statute quickly to just differentiate. I want to make sure that I'm not misstating the county's position. Judge Nardella, I do agree, obviously, that the statute creates new rights, new entitlements, new remedies for these firefighters. However, it's still the county's position that in order to be eligible for benefits under this statute, the firefighter has to be employed at the time that they are diagnosed with cancer.
You know what? We understand that provision of the statute, but you said something interesting here. You said there's a 2-year statute of limitations. So in our case, if we were to analyze whether Mrs. Weaver was entitled, had a substantive right to pursue benefits under the workers' compensation scheme, would she have, due to her retirement being, I believe, 5 years?
Are you talking about the chapter 440 under workers' compensation?
Correct. I'm asking a workers' compensation question.
Okay. I moonlight as a workers' compensation lawyer. I'm primarily a civil litigator, but I'll do my best to answer your question. If she retired from the county 2012, she was diagnosed 2017. I would say, well, let's say, even assuming that maybe her date of exposure constitutes the date of injury, let's say hypothetically that's the case, and that was sometime before say that was 2011, she would have 2 years from 2011 to file her workers' compensation claim. So 2013.
Should we view the statute of limitations as extinguishing a right and saying there's no longer a right? Or I'm going to ask Mr. Barr that question as well. Or is that just a matter of procedure, you would say?
Well, under chapter 440, I mean, statute of limitations are typically, from my understanding, statute of limitations are typically procedural issues. They're not substantive, which further, and to address Ms. Weaver's contention that 112.18.16 is just remedial because it creates an alternative remedy, even if the court accepts that premise, that argument, if it's just not here, section 112.18.16 isn't remedying anything. If the legislature knows how to write laws, the legislature knows where to place laws. If they wanted to remedy workers' compensation, something in the workers' compensation scheme, they would have plugged the statute in chapter 440. They didn't. They created a whole new vehicle for applying and obtaining benefits.
That's the fundamental issue, right?
Absolutely. Yes. And the bottom line, Your Honors, the trial court got it right. For all the reasons laid out in our answer brief, the county lays out a plethora of authority to support our position. The final order granting Volusia County's cross motion for summary judgment should be affirmed. The statute confers new benefits, new rights of entitlement, and imposes new obligations on public employers that were not available or required before the statute's enactment.
Is the substantive procedural dichotomy, is that an obligation-based analysis, or is it a right-based analysis?
Well, to quickly address your mention of procedural, Ms. Weaver only argues that the statute is remedial. In her briefing, she does not raise a procedural argument. She does mention procedural in her reply brief, but we would maintain that argument's waived because it was abandoned, as it was not raised. That avenue was not raised in her initial brief.
Right, so let's say we articulate it rather than procedural as remedial.
Okay.
Under Mr. Barr's argument, is it right-based or is it obligation-based analysis?
It's actually both.
And what's your best case for that proposition?
Okay. Let me see here. Let me pull it up. Alamo Rent-A-Car versus Mancusi, 632 Southern 2nd, 1352. That says that substantive laws create a grant or eliminate a right or entitlement. A statute that creates a new claim, a new cause of action is substantive. And
No. Did that address obligations?
it does. I absolutely have a case here in my list for where a case that says that creating by imposing new obligations. And let me just pull it up, and I cited in our briefing.
Counsel, while you're looking,
Sure.
Mr. Barr referenced City of Lakeland, and he explained it as a case which may have expanded the remedies by saying you were previously able to get attorney's fees, I believe, and now you can also get interest or something to that effect. That would seem to suggest if you were previously able to get one thing, but now you're able to get another thing as well, the right existed, but the remedy was expanded, it's remedial. Do you have a response, or can you speak to that case, City of Lakeland?
Well, actually, City of Lakeland versus Cantonella, that was the case that I cited for just as a factual example of what a remedial change the law looks like. I believe Mr. Barr cited Walker and Laberge versus Halligan. In that case, it's accurate that it was appeal from a denial of a motion for summary judgment, and the issue is whether a statute which withdrew immunity from suit should apply retroactively. And the court held that the amendment was substantive and would not be applied retroactively. The court also held that subcontractors are entitled to rely on the substantive right of immunity from suit, which vested before the passage of the new statute. And the court also observed that the claimant also had a right of recovery under workers' compensation. So we cited that case for the proposition that
I'm sorry, I wrote the wrong case down.
That's okay. We cited that case in our answer brief for the proposition that to rebut the argument that an alternative remedy renders a statute remedial. The fact that the claimant in Walker and Laberge had an alternative remedy, it didn't affect the court's analysis. The court still found the statute at issue to be substantive.
Or you were looking for that case on?
Yes, here I found it.
Okay.
That is, give me 1 second.
No, you only have two. One. No, sorry.
Well,
Got
it's this court, even better. Basil and McFarland and Sons, Inc., 815 Southern 2nd, 687 at pin 692. And here, this court held that, quote, even when the legislature expressly states that a statute is to have retroactive application, courts will refuse to apply the statute retroactively if the statute impairs vested rights, creates new obligations, or imposes new penalties. So to answer your question, Judge Cohen, took kind of the long way, but it is both. A statute that creates new rights or imposes new obligations, that's a substantive change in the law. And on that note, again, I would just repeat our request to the court that this court affirm the trial court's award of summary judgment in favor of Volusia County and find that this statute is in fact substantive in nature and does not apply to diagnoses of cancer prior to its July 1, 2019 effective date. Thank you all for your time.
All right, thank you, Mr. Barr. See that council went over about a minute, so I'm willing to tack on an additional minute for you as well.
Okay.
You proceed.
The bulk of the argument that we've had since we started has been about the remedies. And so I want to go to the case that Ms. Ott cited, the Lakeland versus Cantonella case. In that case, the Supreme Court said, remedial statutes or statutes relating to remedies or modes of procedure, which do not create new or take away vested rights, but only operate in furtherance of the remedy or confirmation of rights already existing do not come within the legal conception of retrospective law or the general rule against retrospective operation of statutes. So everything that we have been talking about, and Ms. Ott, she kept referring to the benefits as the rights. The benefits are not the right. There's not a single case that Ms. Ott decided. There's not a single case that any panel of this court is going to be able, or any member of this panel is going to be able to find that says that the benefit is the right. The benefit is in furtherance of the right. The remedy is in furtherance of the right. The right is the injury. There's nothing that creates the right to pursue an injury that did not exist before this statute was existed. They could pursue benefits for a cancer diagnosis just as they can now. I was confused by the argument, and I think when Ms. Ott was saying that the date of diagnosis is the date of injury, that's completely false under the rules of workers' compensation. No, I don't. We have all had someone in our life who has unfortunately been diagnosed with cancer, and not a single one of them have got cancer the day they were diagnosed. It's a lingering medical condition that at some point is diagnosed. The right vests on the date of the injury, not the date of the diagnosis. So for Ms. Ott to say that,
and we understand that, Mr. Brown.
Okay, understood. Thank you. And Ms. Ott kept referring to rights as things. Rights are not things. Rights are the injury itself. There's nothing that's been presented that.
Well, I don't know that rights are the injury. I'm not sure that I follow that analysis.
Well, the right is the ability to pursue something that happened to you. So in the context of a workers' compensation claim, the right is the ability to pursue redress for an injury. So within the course and scope of your employment. So we're dealing with a situation here, and I know I've kind of beat the dead horse, but cancer diagnosis, the contracting cancer, that is the right. That is the right to pursue. It's not the benefits that are available that are the rights. And that's the point that I'm trying to make.
Counsel, can you go back and help me with this? And we previously talked about it, but I think you could dress it up for me a little bit more. It's the right, it's the ability to pursue redress for injury against a specific person, right? So the specific person in workers' compensation, is it not workers' compensation insurance? It's this pooled risk, or why?
I don't know how
you get what I'm saying. Go ahead.
Yeah, and I don't know how you look at that and say that something that indemnifies someone else is pursuing something other than the person that's being indemnified. And I don't know if that makes sense, but the workers' compensation claim is always going to be against the employer, which in this case is Volusia County, regardless of who's responsible for paying the benefits. The reality is the respondent is Volusia County. If we're talking about a workers' compensation claim, doesn't matter that how they pay it. And
so it certainly matters to the county, and it certainly matters to your client who's aggressively seeking these benefits as opposed to workers' comp.
Well, but the right to receive those benefits has always been there. Who has to pay it is irrelevant to the right itself. And if it's in furtherance of the remedy or a confirmation of the right, which is exactly what the firefighter cancer bill is, it's addressing the remedies, it's confirming the right that already exists.
The right to receive the $25,000 one-time payout hasn't always been there under the workers' compensation.
The right to receive redress for cancer incurred during the course and scope of employment has always been there. If we're talking about
has the one-time $25,000 payout always been there under the workers' compensation?
No, but it's a remedy. It's a remedy. So if we go to the Supreme Court Cantonella case, it's a statute relating to remedies and the mode of procedure. So therefore, it is remedial. The right is the injury. The benefits are not the right. The benefits are just what you are paid because of the injury. So we're talking about dollars and cents. We're talking about remedies. We're not talking about rights. If we're talking about rights, we'd say, well, cancer has never been covered under workers' compensation. Cancer has always been covered under workers' compensation under the right circumstances. So, or where it actually is able to be proven. So here we're talking about remedies. We're talking about redress. We're not talking about the legal right. The legal right has always been there. to file a workers' compensation claim for cancer. I don't know if the court has any other questions. I feel like the issue is it's complex, but the analysis is really narrow. When we're talking about the remedies, whether or not they're expanded or limited, it's a remedial statute. It's not a substantive statute. And so we would ask that the court reverse the final judgment entered by the trial court and remand with instructions to enter a final judgment for Ms. Weaver.
Thank you, counsel, for your arguments. The case was well argued.
Ms.
And
Cantonella, did you have something else?
I just wanted to hear if you had 2 cents on the statute of limitations possible issue in the workers' compensation.
The statute of limitations, I don't agree with Ms. Ott's interpretation of the statute of limitations issue. Again, I don't do workers' compensation claim. I don't even moonlight in it. But my understanding is that the statute runs once you're able to identify that the injury is related to your employment, not necessarily, in a vacuum, the date you're injured, that's when the statute of limitations begins to run.
That makes sense, but let's assume the statute ran in this case. Would that impact our analysis on whether or not there's a new right at issue here with the statute at issue in this case?
No, because I believe the statute is correcting an error or an issue with regard to workers' compensation, which is why I was trying to explain, and I understand why the court cut me off and wanted me to get to the legal arguments, but explaining why the statute was passed in the first place, which is to make it easier for firefighters to receive the benefits that they're entitled to because of a cancer diagnosis, because of how hard it is to prove that cancer is related to the task of firefighting. So when a statute is designed to correct some error or correct some issue as it relates to remedies and benefits available, it is remedial. It is not substantive. I hope that answers your question.
any other questions from the panel? All right, counsel, thank you for your arguments, and we will stand in recess.
Thank you.
Thank you.